Mr. McBroom, take it away.
Regularly scheduled meeting of January 24th, 2024. I am short-term rental chief Bonnie L. McBroom, and I will be presenting the cases to the board for review in today's public hearing. At this time, we would ask everyone to either turn their cell phones off or put them on silent as not to disrupt today's meeting. The procedure will be for staff to introduce the case record. At the conclusion of our presentation, the appellant will present their case to the board along with any person in support. If there is opposition to the case, the board will then hear from those parties. After the opposition has presented their testimony, the appellant will have a period for rebuttal. The board and their rules provide for cases without opposition 5 minutes total for the appellant, including any members of the public speaking in support of the appeal, to present their case and supporting comments. For cases that have opposition, the rules provide the appellant, including members of the public speaking in support of the appeal, 10 minutes for their total presentation and rebuttal of the opposition's presentation. For members of the public speaking in opposition, 10 minutes is provided. This is 10 minutes total for all speakers combined and not 10 minutes for each speaker. The members of the public that want to submit comments to be entered into the record to the meeting that are either in support of or opposition to an appeal, the comments must be submitted to the board's staff no later than 5 days prior to the public hearing. Send comments to the STR board at nashville.gov. Documentation supporters or opponents wish to provide to the board after the deadline can be presented to the board members by providing 8 copies at the public hearing. However, the board may elect to defer cases in order to review any material received after the deadline. The Metro Code requires that these proceedings be taped. Therefore, it is imperative that anyone addressing the board come forward, speak into the microphone, identify yourself, and then make your presentation. It should be noted that that if it is found that anyone has presented false or misleading testimony to the board that would have affected the board's decision, any approval may be revoked at a later date by means of show cause hearing. The board will go through the cases set for the public hearing today. After both sides of the case presentations are made, the board will discuss and vote on the case. The board is vested with the power to act on the cases before us today under the provisions as outlined in section 6.28.035 of the Metropolitan Code. The code requires 4 members of the 7-member board to be present to constitute a quorum. The board rules require a majority vote in the affirmative of the members present to grant the appellant's application. In the event that the majority vote is not achieved, the case will remain on the board's agenda for the next regularly scheduled public hearing. Applications that fail to receive majority affirmative vote at the next regularly scheduled public hearing shall be deemed denied by operation of law. Any aggrieved party may, within 60 days of the entry of an order, appeal a finding of the board under common law writ of certiorari in accordance with TCA 27-9-101 and following to the Chancery Court within the same 60-day period. After this time has elapsed, the board's decision becomes final and no further action can be taken. If you are an appellant and your case is granted, it will be necessary for you to obtain the permit for which you have applied. It should be noted that the permit must be obtained within 2 years of the board approval to remain valid. I submit that all cases have been filed in proper order. All appellants have been notified by a certified mail as required by the code. Affected property owners have been notified and the legal notification sign requirements have been met as required by the code. Chairman Caputo, we're now ready to go ahead and proceed with our first case.
Okay.
First case to be considered today is case 2024-002. Is the appellant present?
This is for 1206B Ireland Street. Terrific. Come on forward.
And apparently we have no opposition. This is, the appellant is Burgess Harrison Yachts. This is an RM20 zone district were now on, after January 1st of 2022, only owner-occupied permits are available. This is governed by BL 2020-187. Therefore, the board has no discretion to lessen the one-year prohibition to apply for a permit in this case. The decision for the board is whether or not the zoning administrator erred in revoking the owner-occupied permit. Based on the evidence that the STRP property is not the principal resident of the permit holders and the appellants. On February 8th of 2023, appellant Harrison Yance and Stephanie Myers acquired 1206B Ireland Street. On July the 6th of 2023, an owner-occupied permit application for 1206B Ireland Street was processed and the permit was issued. On July 31st of 2023, an Airbnb website advertisement was posted. August of 18th of 2023, a VRBO advertisement was posted. On October the 23rd of 2023, Inspector John Phelps was forwarded an email complaint from the short-term rental questions mailbox for condos in the 1200 block of Ireland Street. The complaint was for STRP guests on the rooftop deck at the condos next door. Subsequently, he was forwarded previous email complaints that had been sent to the Board of Zoning Appeals email box. The numerous emails are included at the end of your case file, and the following is the aerial photo of the location on February the 19th of 2023. Inspector Phelps began an investigation and made a site visit to identify the various properties. At the properties at 1207 A, B, C, and D and 1209 A and B Ireland Street are issued multifamily, not owner-occupied permits in 2021. This is an RM20 zone district. Not owner-occupied permits were available in RM zone districts until January 1st of 2022, after which only owner-occupied short-term rental permits were available in RM zones. At 1206 A, B, and C Ireland Street, the owner-occupied permits were issued in July and August of 2023. A neighbor told Inspector Phelps that none of these properties are owner-occupied. Inspector Phelps investigated and gathered sufficient evidence to revoke the 3 permits. And it is the position of the Department of Codes and Building Safety that the appellant's principal residence is 5309B Michigan Avenue, Nashville, Tennessee, 37209. The evidence for the property under appeal follows. 1206B Ireland Street deed of trust lists the owner's address as 5309B Michigan Avenue, Nashville, Tennessee. The deed has a 1 to 4 family rider attached. This waives the number 6 occupancy requirement in the Uniform Covenants section of the deed. Also, in the Uniform Covenants number 10, assignment of rents indicates that the property is intended to be rented and not to be occupied as the owner's principal residence. Old Stone Development LLC, the Tennessee Secretary of State lists the registered agent as Burgess Harrison Yance. The registered agent address and business principal address is listed as 5309B Michigan Avenue, Nashville, Tennessee. Countryland Construction LLC, doing business as Countryland Roofing. The Tennessee Secretary of State lists the mailing address as 5309B Michigan Avenue, Nashville, Tennessee. Burgess H. Yance vehicle registration is 5309B Michigan Avenue, Nashville, Tennessee. The deed of trust for 5309B Michigan Avenue, Nashville, Tennessee, owners are Stephanie Kindly Myers and Burgess H. Yance. There's property owned in Kentucky at 138 North Main Street, Greenville, Kentucky, and it lists the owner as Burgess Harrison Yance and lists the owner address as 5309B Michigan Avenue, Nashville, Tennessee. There's property owned in Wilson County at 665 South Posey Hill Road, Mount Juliet, Tennessee, and it lists the owners as Harrison Yance and Stephanie Myers, and the owner's address as 5309B Michigan Avenue, Nashville, Tennessee. 3 properties owned in Florida, 5100 Hickory Street, Panama City, Florida, 6008 Cherry Street, Panama City, and 322 Raven Lane, Panama City. Owner of each of these three properties, Harrison Yance et al., and the owner's address listed as 5309 B Michigan Avenue, Nashville, Tennessee. Social media of Harrison Yance features a photo of the wedding day of he and Stephanie Myers, also features Countryland Roofing. Stephanie Kindly Myers, Jean Myers' driver's license address is 5309 B Michigan Avenue, Nashville, Tennessee. And Ms. Myers' Yance vehicle registration is 5309 B Michigan Avenue, Nashville, Tennessee. Kindly LLC, the Tennessee Secretary of State, lists 5309B Michigan Avenue, Nashville, Tennessee, and previous STRP permit for 5309B Michigan Avenue Airbnb website advertisement. Photos match Facebook. On November 17th, 2023, a permit revocation letter was sent. December the 2nd of 2023, the permit was revoked. December the 12th of 2023, the appeal was filed. Ms. Stephanie Myers-Yance previously had a permitted owner-occupied STRP permit at 5309B Michigan Avenue from November the 7th of 2019 through November the 7th of 2020. The Airbnb website advertisement for this property is still posted, but has not operated after the permit expired and cannot be booked. However, the photos of the house on the website advertisement match Ms. Myers' recent posts on her social site.
Before we wrap up, Mr. McBroom, is this young woman who's entered come in opposition to this matter? Okay, very good. That will change the time allotment, so good to know up front.
Yes, you will have 10 minutes for your presentation and retain any time you wish for rebuttal of the opposition from that 10 minutes, please.
Okay. So, Mr. Yance, so you understand that if you're probably prepared about 5 minutes to speak. If you want to do that and save the 5 minutes to counter anything that you hear from the opposing witness, terrific. But before you get started, just as a reminder, we need your name and your address for the record, and then tell us all about your situation.
My name is Harrison Young.
Oh, and I apologize. You're going to need to open the microphone. And just press once. There you go.
My name is Harrison Yance, 1206B Ireland Street, Nashville, Tennessee. Okay, so the complaint that was made on the 23rd of October about, I guess that's the only thing that I saw that was provided to me about guests being loud on a rooftop deck. I was never made aware of that. I have a management company that was handling the bookings because my businesses operate in 3 states, so I'm out of town quite a bit, along with my wife. She's obviously not here today because she's in California. She travels quite a bit for work. So we just purchased the property. A lot of the addresses that I had listed as my address whenever I bought this place, I guess it wasn't really triggered as to change the address whenever I bought this place. I've since corrected that, got everything changed over to my address. I guess I didn't realize that was such an issue. I've never really had, didn't pay a lot of attention to that kind of stuff just because I still own the other house that it was originally registered to. But I've since changed everything. I guess deed of trust, there's the loan for that property is not handled by that company that you've referenced in the documents provided to me. There's a property in Florida that was sold, but I've provided all the evidence that I've changed all the addresses to my current address. There was an old Airbnb listing. We tried to rent 5309B Michigan in 2019 or 2020. It rented one time, and we never did. rented again, and my wife she's not great with computers and forgot to delete the listing. We have sound monitors in our Airbnb that the management company that was previously running it, they would monitor the sound to make sure that there was no kind of issues with sound. Also, it's mentioned that there was our guests were on her porch is what it said. I don't necessarily think that's true. No guest would have any reason to go over there. She complains about broken glass. I've also had broken glass. I've had to replace a window. Someone shot my window with a BB gun. I don't have a whole lot else to argue besides I've changed everything over and I've got everything in order to meet your all's rules to prove this is my address. That's all I have for now.
Great. Would any of the board members like to ask anything of Mr. Yance before we hear from the opposing witness? And we don't go too far, because we may have a few questions after we speak with the, Kurt, go ahead.
Can I say one more thing?
Sure, of course.
I don't have any other, Airbnbs. None of these other properties are, listed. None of them are rented out. This is I've only got one. This is the first time I've ever tried to do it, and obviously didn't do it right, but trying to get that right now, so.
Okay, super. As I said, don't go too far, because we may want to revisit some of this, and so, okay, now we have questions.
Hi, so one question that I just thought of. What is the 5309B Michigan Avenue home being used for now, if it's not your residence?
Family members stay there sometimes. My wife uses it to take photos and do stuff for social media.
Okay, thank you.
Sean?
I was just drawing your attention to it.
Okay, great. Okay, why don't we have you grab a seat or move to the end of the table there, whatever you prefer, and we're going to ask your neighbor to come on up. Yes, ma'am. And I know I'll be corrected if I'm wrong, but my understanding is you've got 10 minutes total to speak, yeah? But don't feel you have to take 10 minutes. If you can do it in less, by all means, do it in less. But start off by telling us your name and your address for the record, and then tell us about your observations and what brought you here today.
Okay. My name is Marcia Jordan, and I live at 1208 Ireland Street. And let me add, I've been there 30 years. Okay, this is the 30th year that I've been there. And I've always lived in that area. So I just moved. When I moved there, I'm 57. So when I moved, I've been there 30 years. So before I moved to 1208, I still lived 2 streets over. So I love that area. I love the historical and Fish University, Meharry. So I stay in that area because I love it. And I love the nearby hospitals. I love Midtown. I love Vanderbilt, and I love Centennial, and that's where I want to go over Meharry. So I love that area. I'm just trying to express how much I love it. I've been there 57 years. I was born in that area. Never seen him before in my life, and he's my neighbor. So I don't know the requirement for Airbnb. Do you have to live there sometime or live in that area? But one neighbor, I think his name is Toby. He came over and he thought enough of me living there 30 years to come over and shake my hand and introduce himself. So I really appreciate that. So what I would say about the neighborhood, I never complained about noise. Noise is not my problem. My problem is Airbnbs. Theirs is a nice size, so you have maybe 10, 15, 20 people there. And when you come for an Airbnb, you come to party. I didn't know that because I voted at first to have this because I thought it would bring income into the neighborhood. And it's, at first it was you know, it wasn't a high income neighborhood, but now it's becoming. So, it's an inner city. So, and I would say noise is not my problem. My problem is when you park, and I don't have no problem because I think if you worked all week, you need to party. I got a problem when you partying and you in my window. I got a problem when you running up and down the street or running through just having a good time, which I don't have a problem with a good time. Just don't let it be always at my expense. Now, I can't say they broke my window because I'd be lying. I really think it's the builders who want to take over the neighborhood and don't care about the people that live there, and I'm the only house left now. I'm the only house. Everybody has sold but me. I'm the only house left. I don't want to leave because I love those hospitals and I love the community. But I got a problem at 3 o'clock, and he said he don't believe it, but I've been there 30 years and never had to call the police at 3 o'clock in the morning. But now I do because somebody is partying and having a good time. I got socks thrown in my yard, beer bottles, whatever. I have pictures. You know, I submitted pictures. Now, you saying you don't believe this, I have no reason to lie. I've never complained in 30 years until these big developers or big people who live there, who don't even think enough to introduce themselves and say, well, call me if something happened. Only one did that. And you know, you got all these, I just got one address. I don't have the privilege or the money to live in Florida and then live in here. I have to live at 1208 Ireland Street. That's where I live all my time. So I got a problem when you bothering me at 3 o'clock and knocking on, and I appreciate it. They nice, come on out and party with us. Number one, I don't know you. You know, I don't know you. I'm not going to party with you. And, you know, I don't feel comfortable enough with today's society. So I have a problem with you hanging in my window at 3 o'clock in the morning. Probably, and I don't have no problem if you want to get, you know, I got a problem with drugs when they interfere with me. If it's a drug but when you're smoking something or doing something and I'm getting the aftermath I got a problem with that. Now, I got a problem with that. But I understand you want to, and now they have built something across the walk where they can go over there. I got a problem with if you high and kicking it, or it ain't kicking it, that little kid said turn up. If you turn up and you're not going to be able to make it up 4 flights of stairs to go up to the roof because you're a little intoxicated or whatever. I got a problem with, and I didn't lie, I moved all my furniture off my porch because it's more comfortable to be on the first level when you high than it is to go up to the 4th floor on the rooftop. I don't see too many people on the roof. No, but they made some little walkways where they can go over there and have a good time. So that's my problem. I got a problem when it bothers me. If you don't bother me, I ain't got no problem because I'm old. I stay in my house. I go to sleep about 8 or 9 o'clock. But when it's 3 o'clock and I got to call the police, I got a problem.
Ms. Jordan, let me thank you so much for those comments, and let me just ask a real quick question. So the issue at hand, and I think you spoke to it, the issue at hand is the complaints are unfortunate, and it really, I hate that your, quiet enjoyment of your property is being disrupted. But the issue at hand for Mr. Yance and his wife is whether or not they live there, and that is their permanent and regular address, that they can only have an Airbnb license for that property if they live there. And I believe I heard you say, I've never seen him before.
I've never seen him before, and I lived there 24.
So to just put a fine point on it, is it your belief and your testimony that Mr. Yance and his wife do not live there?
It's my belief that Mr. Yance don't live there, but I don't have a problem with him don't live in there as long as his tenants or whoever don't bother me.
Understood.
I got a problem when it bothers me.
Understood. Very good. Is there anything else you'd like to add? I didn't mean to cut you off, and I'm sure some of my colleagues may want to ask you a few questions.
I've only seen 1206. The only person I've seen is Toby.
Okay. And that's a different home entirely, right?
Yes, ma'am.
In that general vicinity.
It's
Okay.
4 homes, and
Understood.
it's 4 houses at the 1206.
Got it.
And I've only met one person that owns it, who came over and had enough courtesy, enough respect, or enough to think, you know, let me introduce myself, because this lady is here all the time. So
Understood.
just one person.
Very good. Sean, Nicole?
Sure, yes, and yeah, I'm sorry that you're dealing with those nuisance issues. But again, what we're really here about today is the permit was revoked because the city determined that the permit holders did not live at the property. So that's kind of what we're focused on today. You know, at my home, I kind of, every morning when I open my windows, I see my neighbors' driveways across the streets and maybe folks going out to get their mail and which cars are there, and I get to know the vehicles for family members and stuff, just for my immediate neighbors. Have you noticed coming and going? Maybe, you know, not every neighbor introduces themselves to their neighbors, but have you noticed a vehicle that's frequently there? You know, anything like that? Is there any kind of pattern, or is it just kind of always different people?
Oh, I'm sorry.
I'm sorry. Is it kind of a pattern, or is it kind of like always different people?
Looks like always different people. That's why when they ask me to come, it's always different. When they ask me to come over there and party, it's always somebody different to me.
Okay.
When I get up and go walking, it's always somebody different to me. I've never, and I don't want to, I don't want to hurt him, but I don't want his people hurting me either. I've never seen him before. Never, and I live there. I'm retired. I don't work. I've never seen him before.
Okay, thank you.
Anyone else? Okay. Ms. Jordan, thank you so much for your time. We really appreciate you coming down today and sharing your experience with us.
Okay.
Thank you.
Thank you.
And if you don't mind staying just till we finish this case, just in case we needed to revisit any issues with you. Thank you. Great. You can pop back over if you want to add anything.
The appellant has 6 minutes and 26 seconds for rebuttal.
Excellent. Thank you.
Okay, so in between our houses, there is a 8-foot tall privacy fence that would conceal me coming and going. I don't know how anybody would know when I come and go. I wake up a lot of times, you know, 5 o'clock to leave in the mornings. I work a lot in Kentucky or as far out as like Camden, Tennessee, and I get back pretty late. Tracking my comings and goings would be pretty hard. I've seen her out there. I've seen some of the stuff she's done because the builders, which a lot of the complaints were about the builders. I've seen her, you know, talking to the people that work there. I've never spoke to her, but I wasn't ever aware of any kind of problems until it was obviously too late. I don't believe any of my guests are doing the things that she's saying. I've also called the cops on some people. There's, you know, just people in the neighborhood that do bad stuff. I don't really know how to stop whatever's happening at her house, but I know she put up cameras. I don't believe that any of my guests would be doing that kind of thing. Getting on our porch, getting in our windows, that makes no sense. But there's obviously people out there shooting windows out with BB guns and doing crazy stuff, and it's just not anything to do with any of the people that have rented out my property or me personally.
Great.
That's all I have.
Thank you. Nicole, please go ahead.
About how many nights out of the month would you say you stay at the Ireland address?
It just depends. So in November, I guess whenever, or October through November, I was up in Kentucky working on the address that's listed. I've been renovating that property, and I stayed with my mom most of that time in Kentucky. I would say that I'm there half the month.
Okay. And then you said,
But there's months at a time where I'm
right,
gone.
right. And you mentioned that you didn't think of updating paperwork, driver's licenses, that sort of thing, to your new address.
Yeah.
So when did you update your driver's license?
My driver's license was, whenever I applied for the permit, I did, I guess what I needed to apply for the permit.
Okay.
I just wasn't aware, like, it just doesn't click in my mind whenever I buy a property to change everything, because I still own the other property. It's
Right.
not like I wasn't gonna get the mail, I guess.
Right, and you did mention that you're not renting out the other property,
No.
so,
A lot of them, the stuff in Florida I bought, I worked down there after Hurricane Michael, and I bought a lot of damaged properties, and I've just been going down there and working on them whenever I get a chance. They're not livable, most of them. They're just stuff I work on whenever I get the chance.
so you're able to get your mail at the Michigan Avenue address as well? I mean,
Yeah, I mean, I get stuff at all these addresses.
Okay.
I mean, if I've got a project going on, I'll send something to a certain address, but just all over, yeah.
okay, thank you.
Anyone else? Very good. Okay, Mr. Jones, I'm actually going to ask Ms. Jordan to step back up. Alicia, do you think that we could, there was a packet of photos that was sent, I think just yesterday, that has the vehicles that are registered to Mr. Johnson and his wife, captured regularly in front of the Michigan Avenue location. Could we pop those up? I'd like to ask Ms. Jordan to, Ms. Jordan, if you don't mind, do you mind coming back up? I don't need to reintroduce her, right? She's, as long as the hearing's still open? Okay.
Give me just a
Sure,
moment.
sure. It was a separate email. It was a second email.
Sorry, do we need to vote on that as a board, since it's not typical for us to bring back the opposition after the,
I think as long as the public hearing is still
The public
open.
hearing is open, so you can ask, you can continue to ask
okay,
questions, yeah.
great, thank you.
I actually have them up on my iPad. If it's too difficult to find them, I can just show them. Okay. Yes, ma'am.
And, I don't mind him having this permit as long as, I know he don't believe me because that hurts my feelings.
Oh.
But, I don't mind him having this permit, but I want him to watch his tenants and let me be able to email him and let him know what his tenants are doing when it happens.
Those are very reasonable, and those are basic expectations of all Airbnb owners in this city, that you are supposed to have a contact available at all times. So those are the most basic requirements of any Airbnb owner. The issue that we're talking about today is whether or not Mr. Johnson and his wife live there as their primary and permanent residents. And to that end, can we just scroll through these pictures real quick? I just thought of this when Councilman Parker mentioned that when he opens the blinds in the morning, he sees his neighbor's truck, or he sees his other neighbor pulling out of the driveway to go to work. So you'll see here, I think that's a Tesla. Then there's a G-Wagon in picture number 3. And there's a kind of a large white pickup truck as well. And I think those are the cars that are registered. They're kind of distinctive, especially the G-Wagon. It's got Ms. Younce's handle on the side. Have you ever seen these cars, or do you regularly see these cars?
I would know a Tesla and a G-Wagon, that's a Mercedes. I would know that, and I get up at 4 and 5 in the morning too, because I'm old. And I open the blinds, but I close them back, because I don't like people looking in my house. But, I would know a Tesla.
Okay.
But I mean, I hate to hurt them and whatever. I've never seen them.
That was simply what
Never,
we're asking.
ever. And I would know, because the man that came, and I have talked to him, he came up in a Range Rover. I know this cars like that because I'm old. And, I notice it, and I notice my surroundings.
Got it.
And I've never, ever, 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 ever seen them.
Okay, very good.
And let me add this, and we do have a fence in the back, but it's a separation between, like, they built a wood thing, then it's a little space, and you can look between them, and it's no no fence in the front.
Got it. Okay, thank you. Questions, Nicole?
Can I ask Mr. Yance a question?
Sure.
Is there a garage at the Ireland Street address?
Yes, there is.
And do you usually park in the garage?
Yes.
Okay, thank you.
All 3 vehicles?
No, I have way more vehicles than that.
Okay. So these were vehicles that we found registered to you?
Yeah.
Other vehicles? So
Yes.
you've never brought these cars over, so Ms. Jordan
No.
would never have the opportunity to see them? And how many garage spaces do you have?
It's just a 2-car garage.
Okay.
But yeah, those cars have been over there. But I've got stuff parked in Mount Juliet. I've got stuff parked, on Ireland Street, and I've got stuff parked there. I've got one too many cars.
All righty, thank you. Okay, Ms. Jordan, and then I think unless we have more questions, we'll probably wrap this up.
I have 3 cars
Yes.
registered in my name, and I park them all. I don't have a garage, I have a carport. I put them back in the back. I can look, which, right, if I go out the back, you know how, well, you probably don't know how older people are, they look at their, I can look and just stand there, and there's holes between, they didn't build the fence like this and this and this, well, you can't. I don't know, but it's like space between, all you gotta do is look and see who's coming.
Understood.
And I'm outside, I have to cut my own grass, I've never, ever, and I know who's coming because I've been there 30 years.
Yes, ma'am.
Okay, I'm sorry.
Very good. Thank you so much for your time. Greatly appreciate it. Unless anyone has any other questions, I think we will close the public hearing. Good. One more?
Sorry, when would it be appropriate to ask questions for staff?
This would be an appropriate time to do that.
Okay.
But do we close the public hearing before staff or no? No.
You can ask questions now.
Okay.
And you can then reopen public hearing if you'd
Right.
like after your deliberations start.
Max, all yours.
Okay, great, thank you. So I'm sort of confused because I'm seeing the documentation that the driver's license was still in the 5309B Michigan address, but then I'm hearing from Mr. Yance that he updated it before he applied for the permit. So I'm wondering what documentation you all used to issue the owner-occupied permit to start.
Mr. Yance provided the necessary documentation, but what the ordinance requires is not very stringent. I can't say with any certainty, but I would just say that it appears as though he made the change to the necessary documentation in order to submit it for the application. Whether what happened, I don't know. I can't say with certainty, but I know that has certainly occurred many times in the past.
I think if I'm reading the documentation correctly, it was Mrs. Yance's driver's license that still reflects the Michigan Avenue.
Both of them.
Both of them reflect Michigan Avenue according to
That's what I saw in the documentation, but I could be wrong. That's why I was confused as to how.
No, Mr. Yance's driver's license was submitted with the application 1206B.
Okay, great, thank you. And then, do you know if there have been any stays since the permit was revoked?
I can access that for you.
Okay, that would be great if possible.
Mr. Yance, have you had any, we're gonna look too, but have you had any stays since the
No.
permit was revoked?
Whenever I got the letter, I spoke to the management company and I told them to stop. And I think they might have let somebody stay. I was in Kentucky at the time, but I think they let someone stay. Maybe that was in between, like the time that it was revoked and the time that I got the letter. But I told them to stop and then they didn't have any. There was no more guests.
And is the Airbnb ad still posted?
No, as soon, I had to kind of get into it with the management company because they were trying to convince me that I could still rent it and all this other stuff, but I told them that I didn't want to do anything wrong, so they dropped me as a client.
Okay. Let's just let Mac look really quickly and then we'll Go ahead, Ms. Jordan.
Now, can we just, Mr. Youngster, can he just, so you have to live there, can he just do like maybe, Toby, just come over there quarterly and live? No,
So
no.
we'll see how this all works out, and you guys can work out your neighborly relation. But we're just today discussing the fact that the city was given information, Metro was given information that this gentleman and his wife are not residents of that home. The investigation conducted by Metro kind of supports that. So that's really the only matter at hand, okay? Go ahead.
If you'll access your screen, the permit was revoked on the 12th of December. There have been no stays after.
Okay, super. Great. Anything else before we close the public hearing? Okay, we are going to consider the public hearing closed. Thank you both for your time, and we're going to discuss this amongst ourselves. You're welcome to listen, but please don't chime in because the public hearing is closed, okay? Thank you so much. Oh, ma'am, would you mind terribly closing the microphone there? Just press that button. Super. Okay. Nicole.
Sure. Sorry, I'm very chatty today.
Quite all right.
I am a private person by nature, and I'm on the board of my HOA, and I don't know most of my neighbors, I'm ashamed to admit. I'm not a person who introduces myself to everyone on the block, so I'm not totally convinced by that argument. I also think if you have a garage, you have multiple cars, you have multiple properties, it's not unusual to me that someone wouldn't see your car. Looking at the deed of trust, I mean, some of this information in the case summary isn't entirely convincing to me. In the deed of trust, it says that, let's see, the owner address was listed as 5309B Michigan Avenue. That was obviously their address when they bought the new house. They didn't live in the new house yet. In the Uniform Covenants number 10, I don't read that as saying that it indicates that the property is intended to be rented. If you look down at the Uniform Covenants, and it says assignment of rents if the property is leased to, used by, or occupied by a third party. Borrower is blah, 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 blah. So it's giving them the option to rent it to a third party. But I'm not convinced by that in the case summary. I am also not great at paperwork, so I understand not updating all of your paperwork. And essentially, I believe that the zoning administrator erred in this case. I don't think any of the documentation that we've been provided convinces me otherwise.
Okay.
I think I'm falling on the other side of this one and having a hard time finding that the zoning administrator erred. We've got a purported primary resident owner-occupied Airbnb that has as many as 8 documented stays in October. I'd assume most of those are multi-day stays. That's a substantial amount of time for a property to be rented out. That's a primary residence. Some of the language that the appellant used, talking about, what address was registered to the driver's license at the time of application. I think the language the appellant used was they did what they needed to do to get the permit, which, is a box to check, but it's not all that the zoning administrator looks at. And so I'm not convinced that the zoning administrator made an error in determining that this is not a primary residence here.
I'm in agreement. I also believe that based on the evidence provided that the zoning administrator did not err in making the decision. I don't think that we've been provided enough evidence to show that that there was an error made.
I agree with the gentleman, Nicole, I'm sorry to say, but I think that Sean picked it up perfectly. I did what I had to do to get the permit. So we often have appellants who will come to us and say, look at my driver's license. Well, we know you own the house. Of course, you are eligible, and it is within your rights to list that address when you get your driver's license. And of course you do that in order to support your application. But I think that I think Metro did yeoman's work here in documenting all of the, they didn't run across anything that says they do live there. I think that's what always strikes me is they spend a lot of time digging and they found nothing to support that they live there, but they found lots to support that they don't. If you look at the vehicles, if you look at the photos, if you look at, you look at the property list, obviously these folks can live where they choose to. They have lots of options. But I just find it really hard to believe that the zoning administrator was so off base as to find no support that they live there when they do.
So if his driver's license is at 1206B Ireland, that is support that he lives there. I know you may not consider that to be enough support, but I would quibble with the idea that there's no support.
But again, Nicole, they have to get that driver's license
I'm
changed
aware.
in order to support their
Yeah.
application. So they never would have gotten the permit in the first place without
Yes,
that.
I'm perfectly aware, and I've watched every single case that has come before this board and the BZA before it. So I'm well aware that there are people who come before you and have very clearly attempted to game the system. And it's the job of the board to determine if that happened or if it didn't. In this instance, I don't think that it did. I try not to read too much into sentences that people are saying off the cuff when they're being asked questions. I don't necessarily love to parse every individual sentence and sort of take that as meaning that someone had ill intent or was attempting to game the system. We disagree. Obviously, I'm going to get outvoted, but I just want to note for the record that I don't think that the zoning administrator inaccurately sort of used the information that they were able to find, but that doesn't mean that they weren't wrong. I don't think we have to rely, otherwise we wouldn't have people come before us and present evidence. I think we can rely both on the case summary and the documentation, as well as on the statement of the appellant and opposition and supporting parties. So for that reason, that's why I believe the zoning administrator erred, based on evidence that we've been provided that we're allowed to consider. But it doesn't matter because I'm going to get outvoted, so we could just dispose with this.
I think actually, if we're not in agreement, right? It doesn't have to be unanimous when there's only 4 of us?
No.
It's a majority of those present.
Oh, okay.
Just aside from the documentation that we do have a neighbor who came out, Ms. Jordan, and we can talk about the height of the fence, if there's a garage. I'm pretty confident that most folks are somewhat aware of the comings and goings of their immediate neighbors. And I'm also confident that a neighbor would notice those kind of distinct vehicles that we saw in the photos at the Michigan house. And so I think that aside from the documentation that's presented, we have the testimony from an immediate neighbor to support that the zoning administrator did not err in their decision. So I remain
and I'm obviously not convinced by that testimony, but that's fine. We can have different opinions.
All right. Sean, do you want to make a motion to that effect?
I'll make a motion that we find that the zoning administrator did not err in this case.
Second. Show of hands. Okay. Motion carries.
And do you want to ask for opposed?
We have opposed. We have one opposed. So there will be no relief in this case, Mr. Yance. I do believe that should circumstances change, and within 1 year, you're given leave to reapply. Is that correct?
Yes.
Yeah. Very good. Thank you so much for your time today. We really appreciate you coming down and everything you shared with us. Okay, Mac, next case.
The next case is 2024-70. It's 4810 Gallatin Pike, Unit 201, Avery Owner 201 LLC, with a representative Jason Spindler. This is a MUL-A mixed use, so not owner-occupied permits are available here. It's governed by BL 2020-187, therefore the board has no discretion to lessen the 6-month prohibition against applying for a permit. That decision is whether or not the zoning administrator erred in canceling the SDRP permit when it was renewed, when it was not renewed by the expiration date or within the 30-day grace period that followed. Then enforcing the 6-month mandatory prohibition against applying for a permit due to operating with an expired permit. On August the 3rd of 2022, a not owner-occupied multifamily short-term rental permit application was filed. On August the 10th of 2022, the permit was issued to Avery Owner 201 LLC. On December 20th of 2022, an Airbnb ad was posted. On August the 10th of 2023, the permit expired. September the 9th of 2023, the permit renewal grace period expired. The property continued to be advertised and operated as a short-term rental property. On September the 11th of 2023, the SDRP Administrative Assistant Alicia Buffer emailed the contact named on the permit, which was a property management company, Stay Local Nashville, informing them that the permit had expired and the 30-day grace period had ended. She requested to know if they had intended to renew the permit. On September 28th of 2023, Inspector David Frabert received an email from the previous property manager, Anthony Manning, at Stay Local Nashville, which read, "David, I wanted to let you know we received the expiration notice for 4810 Gallatin Pike, number 201, but we haven't managed that property for almost a year. I didn't want you to think that I just ignored the notification. The unit sold earlier in the year, and the new owner decided to self-manage. The ownership history of the property is as follows. Eagle LLC, the developer and owner of 4810 Gallatin Pike, Nashville, Tennessee, which is the development consisting of 20 condominium units. The principal address and mailing address for Eagle Nashville LLC is 3848 Hudson Avenue, Nashville, Tennessee, and this is the home and address of member Edward Tunney of the Tunney Group. Eagle Nashville LLC quitclaim deeded the 4810 Gallatin Pike Unit 201 to Avery Owner 201 LLC, and this is a transfer of ownership of the single unit from the developer to another LLC. Edward Tunney is also the principal member of this LLC, as evidenced by the fact that Edward Tunney's signature is on the short-term rental property application documents as a member of the owner company. Avery Owner LLC 201 LLC, the short-term rental permit was issued to the owner, Avery Owner 201 LLC. Now, the Codes Department was unaware of the change of ownership of the LLC until the permit had expired, and then heard from the previous LLC owner's property manager, followed by a representative of the new LLC owner. Due to the Tennessee Code annotated 67-4-409, not owner-occupied short-term rental permits and properties can be owned by an LLC. The owner can then sell the LLC and change the membership of the LLC to the new owners, and the permit remains intact. And it's convoluted, but it's legal. If a non-owner-occupied short-term rental permit was issued to an LLC that owned the permitted property, then membership of the LLC can change without any effect on the short-term rental permit. The permit remains with the LLC as the original property owner and the original short-term rental permit owner. Metro Codes does not regulate LLC membership. On November 14th of 2023, Jason Spindler sent an email to the SDRP questions mailbox in which he indicated that he is the representative for Avery Owner 201 LLC. According to the representative's statement in the email, the ownership and membership of the LLC changed at the end of 2022. The contact information on the permit was not updated, therefore the courtesy renewal emails that were sent by the Department of Codes to the previous member of the LLC and the previous property manager. Again, according to the LLC's current representative, they were sent an email in the date unknown by the previous LLC member reminding them of the upcoming renewal, accompanied by an image of a landlord registration, not an image of the short-term rental property permit. The current LLC representative said that the previous owner indicated renewal date of 12/31/2023, and the landlord registration renewal was set for that date. On December 4th of 2023, the short-term rental appeal was filed, and the owner about that date, the Airbnb ad was changed to a 30-night minimum stay, and the calendar cannot be booked for less than 30 nights. I began to research this case and to write the summary to present to the board at the appeal hearing on December the 12th of 2023, and while researching the ownership of this property, I found that the current owner, Avery Owner 201 LLC, has a status of inactive and revoked and no agent with the Tennessee Secretary of State. I emailed Mr. Spindler to inform him of this status, and Mr. Spindler responded that he would address it. There are 10 documented stays after the permit expired. The reviews for those stays are included in your case summary. There was one complaint on the Nashville hub that was filed on November the 8th of 2023 that read, short-term rental complaint description. This property has been without a permit since September the 9th of 2023, and it states the permit number and then gives the link for the Airbnb website address. And there were no complaints on the short-term rental property hotline.
Can I just ask for some clarification? Can we roll back up to the thing about the LLC and the confusing but legal part of it? So are we able to determine who the members were of the LLC originally?
We can certainly determine that Mr. Sonny was. We can make the assumption that his daughter was. We don't have documentation to prove that. But nonetheless, if the permit is taken out, not owner-occupied permit is taken out in the name of the LLC, and the LLC is the owner, the membership of the LLC can change, and the permit remains valid.
Right.
And this was due to state law where they actually did the opposite of what they intended when they wanted to do a transfer. But the correction has not been made, so that's still the law today.
Okay. So the membership in an LLC can change, but the permit will remain. We also have had a couple of cases that I think we've let go on this board where an owner created an LLC and was the only member that we've then determined that doesn't really count as a change of ownership.
If the case is that the permit is taken out in the name of an individual who then converts to an LLC and the property ownership converts to an LLC, the original individual is considered the permit holder.
Right.
And so the permit stays with that individual, but if the LLC is subsequently sold and the membership is changed, if the original permit holder is not still associated with it, if managing it, or is in some way directly involved, then the permit is no longer valid.
But in this case, it was two different LLCs with, as far as we know,
Well,
two different,
no, it was just the developer, owner,
yep,
LLC, quitclaim deeded it, this one particular unit to another LLC, which they were also the owner of.
okay,
Then the LLC was sold.
okay.
Membership was changed, permit was not updated with the information.
The permit was not updated and it also expired.
Correct?
Okay. Okay,
That was my clarifying question is, so the issues around the LLC and the ownership and the eligibility, that's not really what we're looking at. We're looking at that the permit just expired on its year renewal basis.
Yes.
Okay.
The reason that we made that explanation is the fact that the permit was taken out with signatures of parties different than the appellant.
Understood.
understood.
Thank you.
Okay. Anyone have questions for Mac before we hear from the appellant?
Just to double clarify, so they never needed to get a new permit, they just needed to renew this one?
That is correct.
Okay, thank you.
And
Well,
go ahead.
let me back up on that. It was a new owner. So it was a new LLC with,
No, ma'am, it was the LLC was
Yeah.
the owner, and the LLC was the entity to whom the permit was issued.
right?
The membership of and ownership of the LLC changed,
Right,
but that did not affect the permit.
right.
And I'll also point out that, like, in this zoning district, there's no need for using complex legal grandfathering. I mean, you can walk in here and get a permit in this zoning district today.
It's not owner occupied permit.
A non-owner occupied permit is what I mean.
Either type.
Yes. So there's a lot of information here about when notices were sent, but, you know, they went to the old management company, et cetera. Do you have an idea of when the appellant became aware of the lack of an active permit for the property?
I am not. I can speculate as to that. It was probably sometime in November, but I have no documentation to prove that. He sent me a copy of an email where the previous member had sent him an email indicating that December 31st would be the renewal date, but that was for the landlord registration. Now, the landlord registrations all renew at the beginning of the calendar year each year, but the permits renew 365 days from the day they're issued.
Yes, sir. Thank you.
No? Okay. Great. Anyone else? Okay. Hi, folks. So we are going to hear from you. Are you both going to speak?
I will probably be the primary speaker. I'm Jason Spindler. This is my wife, Roseanne.
Wonderful. So between the two of you, you have 5 minutes because there's no one here in opposition. So just keep that in mind. And so tell us all about your situation, starting with your names and your address for the record.
Sure. Residential address then?
Yes, please. Yep, that one little button right there. Perfect. Yep, residential address, if you please.
My name is Jason Spindler. My residential address is 200 South, 180 East, Princeton, Indiana.
Roseanne Spindler, 200 South, 180 East, Princeton, Indiana.
Proceed.
Proceed.
Okay, so I was not planning to be here this afternoon. I had court, and so Roseanne was going to cover. On the way down, I prepared a different statement. She had something she was going to provide, but so I'm going to read basically from what I have prepared. We did not timely renew our permit, but have a reasonable explanation for failing to do so. I understand that the zoning administrator's position is that there is no discretion. However, I argue that both the law and the short-term rental office's application of the law allows for the exercising of discretion when an owner is able to show a reasonable explanation. Our reasonable explanation in this situation is that the only communication that we received regarding the permit expiration came from the previous owner of the LLC, and that communication inaccurately told us that we had until 12/31 to renew, specifically, the email said to renew the short-term rental permit. Upon realizing the problem with the permit expiration, that occurred in November, specifically, probably right around the time you received first interaction with me, November the 14th, is when that occurred. And so I immediately got on it. And how I discovered it was I was looking online for my tax bill. And I was digging around, just looking on State of Tennessee's website, Nashville's website, and I eventually landed on information telling me that the permit had already expired. So that communication, again, that occurred November the 14th, 2023. With regard to the status of the entity, you've been notified that it has been essentially declared by the Secretary of State to be, it's lapsed. We're in the process of getting all information to the Secretary of State to reinstate the entity, and we should have that done momentarily. In doing so, I've changed the registered agent so that it is now me. We also, the last thing we need to do is get a certificate of clearance. To get that certificate of clearance, I had to open a Tennessee TAP account. I am in the process, or I am awaiting a response from the state of Tennessee in regards to me providing them with that information to open the Tennessee TAP account. To open that account, I had to locate the EIN for the entity, and I had some difficulty doing that. I contacted Erin Tooney on a couple of occasions, and initially she was traveling, and so she wasn't able to provide it for me. I followed up with her probably about a week ago, basically saying, can you have somebody look for it? Because I can't find it in any of my paperwork. So she got back with me, she provided the EIN, which allowed me to proceed with the Tennessee TAP account, which then allows me to get the certificate of clearance, which will then put me in a position to reinstate the entity. I want to talk about what I believe would be referenced as 6.28.030, subsection B5, small Roman numeral 1. And that provides in relevant part for a short-term rental permit that has received no documented complaints to Metro Codes, Police, or Public Works during the most recent permit period. A 30 calendar day grace period for renewal after the expiration of the permit may be allowed by the zoning administrator upon a showing by the owner of a reasonable explanation other than neglect or mistake for the delay. So the permit expired August the 10th, 2023. Grace period expired on September the 9th, 2023. 2 days after the grace period, and that's up there on the documentation that's been provided to you, the short-term rental office reached out to Stay Local Nashville via email to see if they intended to renew the permit. In that correspondence, the short-term rental office said, I quote, "To proceed with renewing your permit, please answer the enclosed questions. Are you receiving your 45-60 days?" Do I need to stop?
Hold on, one sec. Was that the 5 minutes?
I believe that was the 5 minutes.
Okay. We are at our time.
Sure.
I think you'll probably be able to share what more you wanted to share just through
What?
questioning.
Response to questions.
Okay. So let me start. So you were going to make the point that the short-term rental office had reached out to the previous management company
2 days after.
2 days after the
grace
end
period
of
expired.
and your point being,
So my point is that they have discretion to extend that grace period. under the right circumstances, and I think you have discretion to override them. I mean, if there's a 30-day grace period, but they're reaching out to the rental company 2 days later, then that implies that there's discretion to go beyond that 30-day period.
It says, are the emails going to junk, spam, inbox? I mean, they're allowing them grace, right? We actually received nothing.
Well,
Nothing. Do you know what I mean?
I do know what you mean, and we've heard that before. We also are under the impression, and I believe Matt can speak to this, that these are all courtesy. There's no requirement that Metro alert you, warn you. This is all done out of courtesy. But I think it's a valid point, and Mr. McBroom, if you don't mind me interrupting, you've got a furrowed brow over there, so you look quite serious. But could I trouble you to ask you a quick question? And am I permitted to do that during? Yeah.
You can call him up.
Yeah.
Yes, ma'am.
You good? So, you know, it is kind of interesting that Alicia reached out to Stay Nashville or Stay Local, whoever those guys are. They've been around. A couple days after the grace period expired. Had they still been in charge, and if they went, oh my goodness gracious, our spreadsheet was wrong, we got this wrong, what would the point of Alicia's contact with them have been? Like, what would have come of it if they were like, holy moly, we had every intention of renewing, we dropped the ball? Would there have been grace given to Stay Local if they were still managing the property?
Well, it's all dependent upon the situation. If it's, we do that as a courtesy and it's part of our normal operation. However, if we've received a complaint, then we don't have that discretion to extend the 30. In fact, they're not supposed to even receive the 30 if we receive the complaint prior to the 30-day period beginning or ending. But it's done on a case-by-case basis. And the reason for that is we don't want to needlessly bring people before the board.
Thank you. I'm just kidding. So wait, let me just clarify with you. There was a complaint, right? Was there one complaint saying that this had been operating without a permit? And what was the date of that?
Yes, ma'am, and that is what I was trying to find when you asked, and just one moment and I'll find that.
It says November 8th.
Yeah.
On our case summary, which would have been well after it wouldn't have fallen in the whole, if there's a complaint during the time of the permit.
Right.
So it wouldn't be relevant to their offering grace, I believe.
Right.
That's correct.
The complaint would have come after that conversation would have been had with Stay Local, what have you. Okay, good to know. And the complaint was related to the very topic of this conversation. Hey, they don't have a permit, when they know they don't have a permit now.
Yes, it was exactly that.
Am I permitted to ask a question?
Of course.
Do we know who the complainant was? Is that public information? Because it seems to me like, who knows when this is a condo, it's short-term rentals. Probably 95 to 100% of them are short-term rentals, so how are they gonna know that unit 201?
Because it's online. And there are lots of people who regularly review. If they see a suitcase being dragged down the hall, they look it up. If they are awoken by, the sound of somebody clinking glasses, they look it up. So we don't know necessarily who made the complaint, but it is publicly available information. So we do get lots of complaints from people who are just savvy enough to pop open their laptop and figure out who has a permit and who doesn't.
Can I make a statement?
Of course.
Jason and I work really hard to be stand-up people. We're honest. We're parents of 3 kids. We work nonstop. I try to stay on top of things the best I can. And I mean, I literally had this email from Aaron Tooney on my refrigerator. It says, in September, I recently received a notice regarding the renewal of your short-term rental permit. I want you to make sure you know the upcoming deadline, which was December 31st. So it's like, I know it's not a complete excuse, but like, clearly if I knew it was due, I would have paid it. Like, we're not trying to skirt anything. We truly thought, being new to this, okay, December 31st, that's our permit deadline, right?
Understood.
We didn't intentionally, and we wouldn't do anything intentionally to avoid paying or anything like that. Obviously, we're here trying to correct it.
Sean, did you have a question?
Yes, so understand the error and how y'all came to have the wrong date for renewal. Mistakes happen. So, Mr. Spindler, you indicated that your awareness of not having a permit, an active permit, was around November 14th. We've got documentation of emails that you sent to staff. What did you do with the listings at that point? Like, presumably you had some bookings, presumably there was still a listing on the platforms. What did you do at that
We
point?
had one booking and that booking stayed. It was like a 2 or 3 days.
It was like 3
And-
days after that. An older lady did stay. So that was November 14th that Jason discovered it. I think it was like November 17th that she came. But as soon as Jason was aware of this on the 14th, I'm the one that kind of handles our Airbnb page. I changed it to what David, is that his name, told us, which was the 30-day minimum, and nobody's stayed since then.
Did
So
you-
it's still like a shown listing on Airbnb, but you have to book it for at least 30 days.
And did y'all have to cancel any bookings, or was it just that one that you had at the time?
We
Just the one.
we literally didn't have any more coming up.
Thank you.
It was just slow. We're just getting started, you know.
Understood, thank you. And if I could just ask staff, does whatever we can see through I forget the name of the vendor, host compliance or Granicus, or does what we're able to see from that kind of follow along with their description of sort of how many stays and what not occurred and
Off the top of my head, I believe so, but I can access that for you in just a moment.
And again, looking from the period around mid-November, not the full period of violation, but the period that,
Yes, sir, I
The
can
appellants
access.
were aware.
I can access that for you.
if you would please, sir.
Thank you.
Thank you.
I mean,
Anyone
I'm
else
willing to
while
show you
Matt
the Airbnb listing too, if you would like to see it, to show you that. There was one review that was included in the packet from December. That's not this property. That's a property in Pigeon Forge that we own.
Okay.
So it was in there. That's not this property.
A property, so how many do you own? How many properties?
4, this was number 2, so we've been on a streak. We have 4 total now.
All
3.
within like a year and a half.
Yeah, yeah.
So you're not so inexperienced.
This is,
Yes,
yeah.
this is literally
we bought-
within last.
We bought the first one probably a month or 2 before this one. This is the second one we bought.
All at the end of 22. Well, this one
Those
and
two.
the other one at the end of 22. But we're new in that the other ones are in Pigeon Forge where there are not all these regulations.
That's what I was gonna ask. How
There's
many,
not all of this.
okay, just quick question, clarifying. How many short-term rentals do you have in Nashville?
Just this.
Okay, thank you.
So,
I'm very aware that Nashville has different regulations, requirements. I'm not so much concerned with the rest of Tennessee or the world, but this is your only experience in Nashville.
Yes.
Okay, thank you.
And I am an attorney. I represent units of government. I represent the county where we live. We don't have regulations like this. We're a county of 32,000, right? I understand ignorance of the law is no excuse, but this has been an overwhelming process. To get in front of you today has been an overwhelming process for us.
Well, we're flattered you made the
Yeah.
effort.
There is
On your screens, you'll have the 4 November stays indicated with the reviews. As to the exact dates, that's not indicated on Airbnb. We follow the host tracking, which indicated 4 stays in November. However, we're diligent to check the reviews to back that up because on occasion, host has counted cancellations as reviews.
Well, I know that the host compliance is not an exact science. I mean, I'm comfortable interpreting that as basically in line with what they've shared with us personally.
Yeah.
Thank you.
And I think the review process is not an exact science. Don't they have a couple of weeks? There's a grace period of a couple weeks to allow them to post a review.
Yes, ma'am, that is correct.
Okay. Great. Any other questions?
One more for staff. So, in order to get a permit issued, will the LLC need to be in good standing with the state?
That's actually a separate issue. What we investigated was based upon the complaint. We're nearly 100% complaint driven. However, technically, when that LLC was revoked by the Secretary of State, they become a non-entity. That would kill the permit.
But, okay. Well, I'll leave that to y'all's office
Yeah,
when they come back for a permit issuance. I was just curious timeline.
That was subsequent to this, but yes.
Yeah, thank you.
We're confused enough, Sean.
It becomes a non-entity until reinstatement occurs, and then it's back to life.
I was just wondering how long that might take.
How long the reinstatement process? So the NTAP account, the email said 1 to 2 days, and that was Tuesday night. That was late Tuesday night. So I don't know why I haven't received anything from them yet, but once I get that account, then I can get, as I understand it, my certificate of clearance. With that certificate of clearance, I can send in the paperwork for reinstatement with the Secretary of State.
It's a good thing you're a government lawyer.
It's complicated.
Anyone else have any questions for staff or for these folks, the appellants? Nope? Okay. We are going to consider the public hearing closed. We are going to discuss amongst ourselves, and I don't think I need to tell you, but no chiming in just because public hearing closed. So, when I see at the top of the report that we don't have any discretion, I usually say, oh, we don't have any discretion. But the thought that had it been stay local and they'd gotten a call 2 days later, and this might never have happened if they weren't newcomers and self-managing, you're not going to believe it. I'm inclined to offer some relief here. If we can, I mean, and perhaps we have to put this to Ann. Can we, with what we've heard today, do you feel that we are able to offer some relief?
So pertaining to the grace period, that is like permissive under the ordinance, and I don't see permission to extend that beyond 30 days in the ordinance. Let's see, regarding whether or not, I mean, it seems that you're determining right now whether there was operation without a permit and whether or not the zoning administrator erred, because that would, it invokes what, a 6-month time frame. Is that what we're looking at here, Mac? A 6-month time frame?
6 months, yeah.
Right. If you find that they erred in determining that there was operation without a permit, then you can find that they erred based on your finding of different facts. If you don't find that they erred and that those facts are what they are, then you don't have discretion to change the penalty under our current ordinance.
And,
Sir.
could I mention one thing? So I've talked to Ann about this. She knows I've been confused about this, and I do want to point out that Metro Legal offers advice and counsel. Their advice and counsel, though very much appreciated, is not binding on the board. Is that correct?
We advise you.
Right. But we don't, we have the ability to operate against that advice if we interpret things differently. Is that correct?
You can.
Okay. Not saying that I love doing that, but I do disagree with the interpretation that we don't have any discretion, because when I look at section 6.28.035B, it says that the board shall have jurisdiction to uphold, reverse, or modify in whole or in part the zoning administrator's decision regarding permit issuance or revocation for all permits eligible for review. I think the operative phrase there is eligible for review, and I think I disagree about the interpretation that this permit wouldn't be eligible for review because it came under BL 2020-187. If it wasn't eligible for review, then I don't know why they would be here in the first place, why we would let them apply and waste their time and our time to come here before the board. So I'm inclined to offer some relief, but that's just one person's opinion.
If I may, just in terms of the rationale for any potential relief, I mean, a clear, I think, way to do it would be to begin the 6-month period at an earlier date, perhaps when some lines got crossed administratively. I don't think that staff did anything out of standard procedure or any error. I think that there was lots of clerical jumbles here, and I think it would be reasonable to look at August or September potentially to begin the 6-month.
That's exactly where I was gonna go, rather than determining that we found different facts, because the facts are the facts are the facts. I don't think we can find different facts. But if this ordinance requires only a 6-month waiting period, and as it's been so difficult even to get to today, as we've heard from the appellants, we've already burned some time. We may be able to offer relief in that manner. As it is, they're probably going to need to get their ducks lined up with the Secretary of State anyway. So
would it be February then if we started it back in August when the permit expired? If we wanted to start the 6-month period then? Because I am also persuaded by that rationale.
If we chose to begin the 6 months on August 10th, they would be eligible to apply again on February 10th, I think.
So I will make that motion that we.
But before we make that motion, can we finish discussing that?
Well, we can discuss after a motion is needed.
Okay, then go ahead.
Well, I want to make a motion that we allow the applicant to apply beginning on February 10th, but finding that the zoning administrator did not err in the operation after the permit expired.
I just want to make a clarification here.
Yeah.
So the ordinance says that it has to be a 6-month period from the date of such determination by the zoning administrator or designee. So are you saying that you have the power to override the ordinance and determine a different date than the zoning administrator has determined?
Well,
I make no such claims. And I don't really want to override anybody, but I'm wondering if the date the zoning, can we say that the simple expiration, can we with a straight face say that the simple expiration of the permit is a date of action, is a date upon which a determination was made because the permit expired? So I realize we have to put our head in the sand and ignore the fact that there were stays after that expiration date. But it is holding somewhat to the spirit of the ordinance in that it is a 6-month period. It just, we're fudging the dates a little and saying, rather than overriding anything, we're claiming that date as the date that maybe the zoning administrator did not act, but the permit under the guise of the zoning administrator was expired.
I can see what you're saying and I understand what you're trying to do. Under the current ordinance, and this is my advice, is simply that, I mean, just in terms of the facts, they couldn't have operated without a license if they weren't operating. I mean, I guess when did it occur that there was operation without a permit? That's what I'm saying. So that's the date I believe we're looking at here. And is that the date that you calculated it from, Mac?
Well, the letter of the law is that it's from the date that the zoning administrator comes to the decision, but it's also been interpreted that if the operation continues beyond that point, then the date moves until the operation is ceased.
Okay, thank you. And what was the date of determination?
Would that just be the first stay after the permit expired?
It's, when
Be the
a permit is
last day.
revoked, we have to give 15 days notice. So I'm looking for the date that the actual letter was sent.
And I would just say to me that that would seem strange because say the zoning administrator doesn't notice for 6 months that the permit holder has been operating. Say we have the same exact situation, the zoning administrator or their designee staff don't realize, then they realize, they revoke, or they send notification that they're operating without a permit after 6 months, then if we couldn't start before that 6 months, it would be a whole year since the permit expired. It's like we're waiting for the zoning administrator to realize it in order to trigger that time period.
It's the duty of the permit holder to have the permit and to keep it renewed and in good standing.
Right, but we exist to offer relief in cases where we feel relief is justified. I mean, otherwise, we wouldn't exist.
So under the current ordinances, there are just very limited circumstances in which you can offer the kind of relief that you're interested in.
Yeah.
And in the past, when there are different, there are different flavors of this ordinance, and
Yes.
in some cases where we have more leeway, we have chosen a different date. We've chosen a date that was the last documented stay, or we've chosen the date that the appellant removed the listing. So in those cases where we have a little more leeway, we've certainly found a way to be more creative. We're just trying to find a way to be creative this way, in this case, without being complete scofflaws.
Right, and I'm not trying to be a scofflaw, I just have a different interpretation, and I think we are allowed, as a board, to have a different interpretation. I'm not trying to break the law or bend the law, I just simply have a different interpretation of the law.
I think that it's reasonable, what the appellants have presented, that, and especially brand new with the change of the LLC and all that, I get it. And I think that it would be reasonable for there to be some kind of for that to be recognized and there be some kind of a relief offered. But I also have difficulty in seeing that the administrator made a mistake. Because I think that the decision was that the zoning administrator made was also reasonable. And so I'm kind of torn, and I also have some problems with massaging our interpretation of the ordinance to fit this one case. I'm very sorry, I don't really have a way to get through it personally.
Yeah.
But I don't believe that we should be reinterpreting the ordinance when I think it's fairly clearly spelled out. I don't know how to get through that personally.
I would just say I also think it's very clearly spelled out, and I have the complete opposite interpretation. And I would not be attempting to massage the ordinance for this one case. This is my understanding of the ordinance and has been my ordinance since before I joined the board, and it's an understanding that I've gone back and forth with staff and Metro Legal about. So this would be my understanding and how I would apply it to every case, is that we do have the ability to uphold, overturn, or modify in whole or in part the zoning administrator's decision. So that's my interpretation, and I understand it. We're a board and I'm one person, so I'm fine being overruled on that.
So I believe that we do have the ability to overturn that, but I'm wondering what grounds you have for that.
I'm not suggesting that we overturn it. I'm actually suggesting that we modify it.
I don't think we can do that.
Right, I think we can, but we don't agree on that. Metro Legal doesn't agree with me on that. So I'm perfectly clear that I'm gonna get overruled on this. I do think that we have the ability to modify, based on our duties in section 6.28.035B.
In this particular incident, a revocation letter was not sent. The appellant contacted Inspector Frabet and was told that the permit had expired. Let's see. By email. So it would have been there would not have been a revocation letter sent in that case.
Do we have a date of that email or that communication?
Was that the November 14th to 16th timeframe?
I believe November 14th was what I had in my notes.
Yeah, I think that's correct.
And
That's correct.
And if I can, if we upheld the zoning administrator's determination, upheld the 6 month, it is 6 months by code, we can't modify that, but established a date of determination, because it seems like in this case, the appellant actually came to the department rather than a determination being made and then notifying them. So, again, I'm comfortable with that narrow shift of finding that the zoning administrator did not err, but modifying the date of determination of violation. And, maintaining the 6 months that's required in the ordinance, but setting that date. I know we have a motion on the floor, but I think there might be different arguments for different dates, but that's my suggestion, and I'm not a lawyer, but.
So would you suggest that we call the date November 14th because that was the date of determination?
That's the date that the appellant reached out to staff, is my understanding.
Right, and was informed that the permit was expired.
I think that's.
Or earlier,
I'm inclined by the circumstances to find earlier, but I need a grounds for doing so.
Right, that's what I'm kind of.
And I erred earlier when I said that we had to give 15 days notice. That's a revocation, not an expiration.
Right. Can
Nobody
anyone
agrees with my grounds for doing so I'll just stop.
No. I understand that we're not in agreement about our abilities here, but give me pick a date and tell me why that date and tell me how we can hang our hats on it.
I don't particularly want to do that, so I would let Councilmember Parker, who seems more inclined to, his argument seems, that's not how I would want to approach necessarily the case. I think, I don't know, it gets messy.
I think it started messy. I don't think it is messy. It is messy, so.
Yeah. The grounds for September 11th is that's when a courtesy notice was sent to, but again, it's not really the fault of staff because they sent it to the folks whose names were on the permit.
Sure.
So it's like, I don't know, I'm kind of struggling with this one. If you guys, I think we all are. So
Yep.
I'm not going to make a full-throated argument for that, but I might support a motion to go with September 11th. I don't know.
Mike, how would you feel about that? I'm with you in that. I think what you were saying earlier is we don't really have justification. We also don't want to set a precedent for every person who comes in. And we've had a lot of these cases where people let their permit expire, and we read the ordinance to say we didn't really have a lot of discretion, and I think we have on a couple of occasions set the starting date although it may have been a different version of the ordinance, but we set the starting date at the date of the last stay, or the date of the last communication, or the day they took their ad down. But I think in those cases, we had more discretion than we have in this version of the ordinance.
May I ask?
Please.
Ms. Mickelson, what is your interpretation of, it doesn't seem like a firm date of determination has actually been made in this case. What is your interpretation of us making a date of determination for the 6 months to begin?
So if you're working under operating without a permit, right? So there has to be operation. I guess it depends how you are going to define that. And my understanding is here it's been found, right, that the property was rented out without a permit. Whenever that date was, that seems to be the date that the zoning administrator has worked from, and from their knowledge of that.
The language is advertising or operating in the code.
So it seems here, right, the determination by the zoning administrator. All we have there is that moment of decision after they were contacted, it seems to me, but those are facts for you to determine.
I continue to struggle, so I'm sorry I don't have.
I have a question for legal. Are the decisions of this board precedent setting, or do we judge each case on its own merits?
Generally, each case is distinct legally, right? In practice, you will find cases come back and facts patterns come back, and people are aware of your past decisions, but you can distinguish based on the facts of each particular case.
Also, this is not the final arbiter of this. If the appellant, if we come up with something, or if we feel that we can't come up with something that satisfies them, they do have another recourse, do they not? In appealing to, environmental court or?
Chancery.
Chancery.
That's
So
correct.
that is at least some comfort if you're uncomfortable with the fact that we may not be able to find a way to offer relief to this appellant.
That's not comfort to me personally, because I think by the time you got through Chancery Court, filing all of that, you would have already passed. If we set a year timeline, they probably wouldn't have it resolved by then, maybe. So if we did 6 months from today, they probably wouldn't have it resolved in Chancery Court. So that's neither here nor there. So, I mean, I would still support the expiration of the permit as the date from which we start the 6 months. And would love for us someone to make a motion other than me, because my motion wasn't seconded, so.
I find it very reasonable, very easy for me to set this date at the last day, right? That's an easy win there, which is the November 20th or 21st, something like that. I want to try to find a way to set it before then. I don't know of a way to do that, but that's what I would like to try to find.
I'm going to have to reopen the public hearing in order to let you speak. I will do that, but please be respectful. I will. Okay. Let me reopen the public hearing. I reopen the public hearing so that we can hear from learned counsel.
Could you turn your mic on, please?
You're looking for something to hang your hat on, and I think the September 11th email from the zoning office is what you hang your hat on. They were exercising discretion. You've got discretion. Why would you exist if you did not have discretion to overrule what they've done? They were going to entertain extending a permit past the grace period on September the 11th to stay local Nashville. That's all.
I am now closing the public hearing. Thank you. Go ahead, Mac.
When I said that these reviews were done on a case-by-case basis, that we notify them after the permit is expired, it's based upon whether or not there's been a complaint. So that is, if there has been, then we're allowed no leeway. We just say he's operating. And this case is complicated due to the fact that we did not know to whom to send a letter of expiration because we didn't know the new members of the LLC. We were under the assumption that the people that made application for the permit were the LLC.
We completely understand that, Mr. McBroom, completely.
And I want to be clear, I'm not suggesting that staff did anything wrong. I believe that they did their jobs, and I think they're doing a great job. And yeah, that's not, I don't have any issue with the way that staff approached this from the staff side.
Yeah, and my read of that situation with the email is that they weren't offering to extend the grace period. They were trying to let folks know that, you're going to be found out of compliance if you don't get a permit here. So I don't think that was anything unusual. But again, we're trying to find a date that we can have a reasonable support for and feel good about any precedent that's being set on. So
I think it's September 11th. That was the first communication from a staff member to the prior LLC members or registered agent. So I'm just going to try. I'm going to make a motion that the appellant be allowed to apply for a permit 6 months after September 11th, 2023. I'm not going to try to do that math right now. That's my motion.
I'll second it.
Okay. Can we see a show of hands? The motion carries. So, and Anne, I beg your forgiveness. So the appellant has been granted no relief, if you will, but the new date of action from the zoning administrator is being recognized as September 11th. So 6 months from that date, the appellant may reapply for the short-term rental permit. And I believe that is all the business we have for today. Okay, then the public hearing is closed.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.